it's an honour to present to the House the Joint Committee on Human Rights report into the Mental Health Bill. As members will know, the Joint Committee is a cross-party body of both houses, chaired by Lord Alton of Liverpool, whose remit is to examine matters relating to human rights within the UK, including through legislative scrutiny. Over the course of our inquiry into the bill, we have examined legal frameworks, witness submissions and, crucially, the voices of those with direct experience of the mental health system. As part of our inquiry, the committee convened a roundtable with individuals who had experienced detention under the Mental Health Act. Their testimonies were powerful, candid and often harrowing. They spoke of the trauma of being sectioned, the overuse of medication and restraint, and the disempowerment of being detained in facilities that too often felt isolating rather than therapeutic. Participants have since shared with us how important this visibility was to them, to see their evidence truly listened to and shared publicly. Hearing directly from people with lived experience was not just informative, it was essential. These conversations grounded our scrutiny in the realities faced by patients and families, and the insights shared at that roundtable shaped our thinking and sharpened our final recommendations. As one participant told us, lived experience matters. Using it to inform policy should be the standard, not a shock. I would like to take this opportunity to thank all those who contributed to the roundtable, often at the cost of revisiting past trauma. The committee is also grateful for the expert work of the committee's legal counsel, particularly Alex Gast, who led on this work, as well as Tiago Simões Froio and Hafsa Said, who led on the delivery of the roundtable event. What became clear over the course of our scrutiny is just how overdue the Mental Health Bill is. It will introduce substantial changes to the Mental Health Act, which provides the legal framework for the detention and compulsory treatment of people with mental disorders, an outdated term, but one that still remains part of our law. The changes introduced by the bill will bring our mental health legislation into the 21st century, strengthen patient rights, and help end practices which bring more harm than good. When people hear about detention under the Mental Health Act, many instinctively think of those who have committed the most serious and violent crimes. They picture high-security hospitals like Broadmoor, which happens to be located in my own constituency of Bracknell. I've had the opportunity to visit Broadmoor. The work they do there is outstanding. It's vital, world-leading work that deals with some of the most complex and challenging cases in psychiatric medicine. But let us be clear, the reality of detention under the Mental Health Act is not limited to high-security hospitals or individuals convicted of serious crimes. Many people detained under the current Mental Health Act are not criminals. Many of them are children, young people, and adults with autism or learning disabilities who are detained not because they pose a danger to others, but because the support they need in their communities simply isn't there. This isn't just inefficient, it can often be deeply traumatizing and raises significant human rights concerns. That's why the committee welcomes the major changes introduced by the government's bill. The bill will end the detention of individuals under Section 3 of the Mental Health Act solely on the basis that they are autistic or have a learning disability, tighten the criteria for detention, requiring decision makers to consider the nature, degree and likelihood of harm before deciding to detain, introduce the concept of a nominated person to replace the outdated nearest relative system, and it will remove police stations and prisons as places of safety for individuals in crisis. As stated in the evidence we receive from witnesses, these are important, welcomed and long-awaited reforms. They reflect the breadth of the government's consultations in this area and prove that the government has listened to the information it received. While welcoming the bill's direction of travel, the committee believes there are areas in which the government could go even further to provide enhanced protection for human rights. That's why we have recommended a few key amendments based on the evidence we received during the inquiry. First, we recommend a new clause to ensure that children detained under the Mental Health Act are only accommodated on adult wards where it is demonstrably in their best interests. Second, we recommend an amendment to Clause 1 to include equity as a fifth guiding principle under the Act. This principle would refer specifically to addressing inequalities in treatments and outcomes, particularly on racial grounds. And I welcome the fact that the Health Secretary, in the debate on the second reading on Monday, recognised that, to quote, people from ethnic minority communities, especially Black African and Caribbean men, are more than 3 times likely to be sectioned. Our report found that adding this guiding principle of equity to the Act would do more to address this racial disparity. Third, we recommend an amendment to Clause 32 to shorten the review periods for restricted patients who are discharged into conditions amounting to the deprivation of liberty. The first review would be required within 6 months rather than 12, and subsequent reviews would take place annually rather than every 2 years. These key amendments come amidst a range of other recommendations. Recent case law has shown that mental health patients in state-commissioned and funded but privately provided care do not come with the protection of the Human Rights Act. This is a loophole which needs to be closed, and we recommend for the government to do just that. We also heard evidence that the question of when the Mental Health Act and when the Mental Capacity Act should govern a patient's deprivation of liberty and treatment is far too complex, raising human rights concerns, not least because depriving a person of their liberty on any grounds can only be justified if the legal basis is clear. We therefore recommend that the government carry out an urgent review and provide clarity that is lacking on this issue. Another crucial area covered by this bill is the rights of children who are particularly vulnerable when assessed or treated under the Mental Health Act. Many of the proposed changes to the law would be positive for children, including the introduction of an opt-out approach to receiving report from independent mental health advocates. We recommend, however, that the government consult on introducing a statutory test for assessing whether under 16-year-olds are competent to consent or refuse consent to treatment, a cornerstone of compliance with a child's human rights. What the committee also deems vital is that prisoners whose mental health makes them unsuitable for being held in prison are transferred promptly to appropriate settings. Keeping them in prison may result in human rights breaches. The report therefore welcomes the bill's introduction of a statutory 28-day timeframe for hospital transfers, and relevant data should be collected and made available to monitor and help ensure compliance with this standard. Madam Deputy Speaker, the committee also welcomes changes to restriction orders placed on a small number of offenders detained under a hospital order. But the government should consider introducing more prompt and regular reviews by the Mental Health Tribunal to ensure that any loss of liberty is justified. Witnesses told us that in the absence of effective support in the community, autistic people and people with learning disabilities could still end up in unjustified detention on other legal bases. The government has stated that the change in the bill will come into force only where there are strong community services in place. But it's vital this does not lead to delays in the much-needed reform. We therefore welcome the government's commitment to provide a written ministerial statement to both Houses of Parliament on an annual basis, updating on progress on implementation. In terms of what more the bill could do to improve the prospects of patients receiving timely care in the community, we also ask the government to consider introducing an English equivalent to the right to a mental health assessment that applies in Wales. Finally, Madam Deputy Speaker, let me just say that this report makes clear that there is much more needed to fix the broken mental health system in this country. And I know the government recognises this as well. This is a small, targeted bill which will not change everything, but the changes it does introduce are significant and long overdue. The government's also committed to introducing mental health experts in every school, setting up young future hubs, and recruiting 8,500 more mental health staff. By focusing on community-based interventions and driving down waiting lists for mental health support alongside the welcome changes in this bill, we can turn the tide and fix a broken mental health system, so that the human rights of all those with mental health needs can be properly protected and they can get the support they need. I commend this report to the House.